Fifth Planning Board meeting to order. And the first on the agenda is Paul reading the huge instructions. Go ahead, Paul.
In accordance with the governor's order suspending certain provisions of the open meeting law relating to the 2020 novel coronavirus outbreak emergency, the August 25th, 2020 Falmouth Planning Board shall be physically closed to the public to avoid group. Alternative public access to this meeting shall be provided. The meeting will be televised via Falmouth Community Television. 2, time public comment can be addressed to the planning board. Zoom virtual meeting or for remote access. Application will allow users to view the meeting and send a comment or question to the chair via the chat function. Submitted text comments will be read into the record at the appropriate points of the meeting. Zoom login instructions. Instructions in the meeting link for this specific meeting can be found at the following web address: www.falmouthmass.us/1112/planning board. Please plan on 10 to 15 minutes of preparation time to log in, though it may be less time if you've previously used the Zoom on the device you will use to access the meeting. Excuse me. Additionally, public comment may be sent in advance of the meeting to planning@falmouthma.gov at least 5 hours prior to the beginning of the meeting. Documents and audio or video files may also be submitted as email. Submitted and email comments and documents will be made part of the meeting record and may be read into the record, summarized, or displayed during the meeting at the discretion of the chair. 4, applicants, their representatives, and individuals with enforcement matters before the planning board may appear remotely and are not required to be physically present. Applicants, their representatives, and individuals with enforcement matters before the planning board may contact the planning department to arrange an alternative means of real-time participation if unable to use the Zoom virtual meeting software. Documentary exhibits and/or visual presentations should be submitted in advance of the meeting to planning@falmouthma.gov so that they may be displayed for remote public access viewing. You're muted.
Okay, now I'm unmuted. Paul, you're still on for the minutes.
Yeah. I recommend approval of the minutes of August 18th, 2020 as corrected.
Second.
It's been moved and seconded that the minutes of August 18, 2020 be approved as revised. All in favor, please show by raising your hand. Okay, 707 here. Thank you. The first on the agenda is a request for release of covenant, Jensen, Boxbury Hill Road. And Tom is going to speak to that. I believe Mr. Jensen is in the, yep, okay, he's being elevated. I miss Jensen too. Thank you. And Mr. Jensen, you're on mute. There you go. Nope, you're still on mute. We see you.
There we go.
There.
Okay.
And did you wish, is it your wife? Tina
She's on
Jensen?
too. She's on too. I'm on the
Yes.
road. I'm on the
But
trip.
she's not going to be shown. She's just participating without.
She's welcome to if she wants to.
That's okay. I was just making note of that. Thank you.
Okay.
Please go ahead, Mr. Jensen.
Okay, we had a covenant put on the property. This was with the town. This was back in 1989, I think. It was with my father. He was going to do a development with our property, or at least he was looking for approval for it, but that never went through. It never materialized. Now it's just, we got it in a forestry plan now. So the only lot on that property is my piece of land, which we built 20 years ago. And so we've had a house on there for 20 years. We have town water. The covenant states, for one, I don't think it matters to us. It doesn't affect us, but if it does, we have town municipal water, we have electricity, and we've been, paying taxes for the last 20 years. So this thing should have been taken off. I went in front of the planning board when I built the house back in 98. I had to go in front of the Cape Cod Commission also when I built the house. And so this should have all been resolved, but when we were trying to sell our house now, and so this was found in a title search by the buyer's attorney. So I'm just trying to be getting released from the covenant. I mean, it should have been, as long as you have municipal services, you're released from the covenant. That's what the covenant says. And so what didn't happen back when we built the house in 99.
So the covenant is, because of its terms, is rather of a moot point right now because the terms have been met.
That's correct.
Okay, and Tom Bott has further explanation, I believe, Mr. Jensen. Tom? You're muted, Tom.
Thank you. If I may just share the screen.
Sure.
Thank you. So likely what you're seeing right now is a copy of the subdivision plan
Mhm.
from 1988, showing this corner of the property in the bottom right here. I can zoom in a bit bigger if you like. So essentially, the subdivision plan was in this corner of the property. Mr. Jensen's property, 515 Boxberry Hill, is here in the middle of the property, and down on the bottom you see the remnant of the subdivision layout here. Mr. Jensen's lot was created by this A&R plan in 1999, as were two other lots and then a third lot in this corner here. And none are subject to the covenant because the covenant was for the subdivision here in the corner of the property. And while the original parcel 1 was included in the subdivision, the planning board at that time had a provision in their decision that the subdivision would be automatically rescinded as of a certain date if the improvements weren't put into place. In fact, in 1991, that was expiring. And then in about that same time, they filed an extension of the covenants until, I want to say, 1996. I have that on another screen here, but I don't want to trouble the board with too much of this. So the subdivision went away because of a lack of performance. The lot 3 was created after the subdivision, and it fronts on Boxberry Hill. It is really not the subject of the covenant, nor were the other 3 lots created up here in the far left corner as well. So as I pointed out before, this is an artifact from an earlier subdivision plan. Much like that commercial property we saw on West Falmouth Highway, where there was a covenant remaining for a subdivision plan that was actually office buildings at that time. So it's an artifact. It's puts somewhat of a cloud on the title that someone had seen. So in my opinion, it's perfectly appropriate to release lot 3 from the covenant. Nothing else is being released from the covenant, only lot 3, although it's entirely moot because the plan was never executed. In fact, if you see here in the bottom of the plan, where the cursor's at right now, that is actually where one of the other subdivision lot was going to be initially. And you see both here and in the GIS that there is not a, let's see if I can get this out of the way. Both here and in the GIS, let's try that one. There is no second lot back there. So 515 Boxberry, Mr. Jensen's lot, the other 3 that were created out of this in earlier dates through the A&R process as well. I'd be happy to take any questions.
Okay. Does anybody have any questions of Tom? Yes, Jim.
Is there a letter in the file saying that the subdivision has been rescinded? That's all I asked, if there was a documentation.
The decision from the planning board from 1980 had an automatic rescission. So if you didn't perform, the subdivision was rescinded. It's not a bad thing to put in all of our subdivision decisions, and some people. But there's nothing in the file that says the subdivision has been rescinded, other than the planning board's decision that says it's automatically rescinded if they don't build the road prior to this date.
But didn't they ask for an extension at one time and try to keep it? I'm just a little unclear about,
I'd say one thing,
Let me
yeah,
get-
just to let you know that I
Yes.
saw that extension too. The extension actually had 4 signatures of my parents and my aunt and uncle. None of them signed it. So I don't know how that thing came up. Nobody signed it.
okay, then
If you
we
look at it,
shouldn't,
if you look at that, Tom, I just saw that when I was looking through stuff and I'm like, there's a thing there on file with the register of deeds and nobody signed that. You guys did the extension. I don't know how that worked out, but there was signature blocks for those 4 people.
see,
nobody
it's
signed it.
recorded. Somehow it should make this go away and we'd be all set. Can we do that tonight?
As soon as the board makes a motion to say we release lot 515 from the covenant, it'll all be gone away.
So move.
Second,
Okay, it's been moved and seconded. Is there any further discussion of this matter? Okay, please, show of hands in favor of releasing the covenant. Okay, all 7 of us, by show of hands, have voted that. Thank you,
Thank
Mr.
you.
Jensen.
Thank you. Is there a way I could get a copy of that somehow to email to me, Tom, or no?
Absolutely. I'll be signing the release of the covenant and forwarding it on to you and to the attorney.
Okay.
So as soon as I'm done here, I'll be signing that document.
Thank you so much. I appreciate your help, people.
Very well.
Well, thank you. Okay. All right, next, an approval not required plan. The applicant is Cove Cottage LLC and 108 Sea Pit Road LLC. Plan of land to adjust boundaries among 3 existing lots located at 24 Reed Path, 32 Nichols Road, and 108 Sea Pit Road. Holmes and McGrath is the engineer, and we have Bob Ament here with us tonight. And Mr. Ament.
Pat, members of the board, good evening. For your record, I am Bob Ament. I'm the attorney for the LLC, Cove Cottage LLC, that owns some of this property, and 108 Sea Pit LLC. Both LLCs of the same family. I'd like to share my screen if I can figure out how to do that, and show you these plans. So this is a plan of existing conditions, and it shows the 3 properties that are owned by the Peterson family, with houses that date back to 1950 in 2 cases, and 1 house that's older. So this is land court property, and this is the house on existing lot 23, land court lot 23 for 108 Sea Pit. And this is the house that's mostly on this combined parcel of lots 25 and 26 land court property. This has a street address of 24 Reed Path, and this is a Reed Path which was laid out before 1950, I believe. And this is lot 28 and 27, and there's a house on that lot, and it's called 32 Nichols Road. So we have a property, or 3 properties together owned by the family: Nichols Road, Sea Pit Road, and Reed Path. Well, there are a number of zoning nonconformances with these old properties. You can see that 108 Sea Pit, this lot, has virtually no frontage. I think it's 14 feet on a angle at the end of a Reed Path road, and that's the way the land court plan was approved. I note that it's not a zoning issues, but the septic system for this lot is in a rear location here. It's a cesspool. It's a little more than 50 feet from wetlands. And one of the goals of the family is to install a new Title V septic system, and that's part of what we're trying to accomplish. Moving over to the middle lot, to the 24 Reed Path house. Note that this house extends across the present property line. So it, of course, although protected because of its age, is in violation of the setback requirements. It does have a modern Title V septic system that's set fairly far back from wetlands and is in this location. The next plan I'll show you actually shows the septic locations. The property known as 32 Nichols Road is unmarketable, as is the middle lot, because of this encroachment into its property. It's also a little too close to Nichols Road, and there's a shed that's in the front yard. Those are minor issues that can be resolved even with just a designation of one of those streets as the front yard. But the intention of the family is to adjust the lot lines to solve these some of these zoning problems, and then get zoning relief as necessary. So what I'll try to do now is go to the A&R plan, which shows what we're trying to, how we're trying to adjust the lot lines. And it says I've closed the sharing, so I'm going to do that again and try to select the right plan. Okay. So my hope is that you now see a plan entitled Plan of Land, and it shows new lot lines. This plan shows lot 218, 219, and 220. Is that a plan that you all see?
Mhm.
Yes.
Wonderful.
Yep.
Okay. So this is the plan that's before you tonight for approval not required endorsement. And what we're doing is taking advantage of the provision in the zoning bylaw that says that the shape of two or more contiguous existing lawful building lots may be changed, provided the area of each lot remains the same or meets current requirements, and the total number of building lots is the same or less. And it then says reconfigured lots shall not lose their building status, and no lot shall be made non-conforming. And that means no lots made non-conforming as a result of this change. So we have existing non-conforming lots, and they will remain, the new lots are non-conforming as well. They're undersized for one thing. So this plan does show in a dashed line the old lot lines running parallel to Reed Path and Nichols Road. Our proposal is to make lot 218 at 108 extend all along the frontage of Reed Path and for 40 feet along the frontage of Sea Pit Road. And the purpose of that is to give us a location outside of Conservation Commission jurisdiction, far enough away from wetlands to meet the town's Title V requirements, and to be able to install the septic system that's shown here, removing, as I mentioned, the septic system that's close to the house. Now, to do that, we're proposing a portion of this new lot to be only 40 feet wide. Well, the zoning bylaw allows by special permit from the planning board, a separate application which was filed and which is on your future agenda, for topographic reasons or other physical conditions as allowed, allow a portion of the lot to be 40 feet wide instead of 50 feet wide. And you're allowed under the bylaw to reduce the width by up to 20%. And we've done this in at least one other case I'm aware of. And we're able to put the septic system in this area that's 40 feet wide. Now, this new lot has 100 feet of frontage on Reed Path. It has additional frontage on Seapit Road compared to the existing 14 feet of frontage at the end, if you can call that frontage, at the end of Reed Path. So this is allows for a significant improvement of this lot. But in order to make this work and have 40 feet here by special permit, we end up having only a small setback of the Reed Path house from the new property line. And this is only 2.8 feet setback. But we're eliminating the much more significant nonconformance of having the lot straddle, the house straddle the property line over here. And we're able to keep the existing Title V septic system that serves this house. Finally, we would create a new lot of 16,335 square feet, which is the same area of the present lot for 108. So each of the lots is the same area as one of the existing lots. And we would now will have the ability to build a new house outside of Conservation Commission jurisdiction in this area, utilizing the existing septic system, and we'll be able to remove this house, which is in Conservation Commission jurisdiction and is dated, and the family would like to replace. So what we have here is basically a family compound of old houses with existing environmental and zoning problems, and we think we have a good way in which to solve it. Now, approval not required endorsement of a plan like this is, of course, without regard to zoning. We know that these new lots remain undersized, but they're the same size as the existing lots. We know we're creating a lot that requires a planning board special permit for a portion of it to be 40 feet wide, but again, means now we have actual frontage that actually meets the bylaw requirements and a good place for a septic system. This lot, the lot doesn't have any zoning dimensional problems other than size. It's the same size as one of the lots that exist today. But by creating the new lot for 108 and getting this house so that it is not crossing a property line, we do need a special permit. That would be from the Zoning Board of Appeals. The property, the house is presently non-conforming as to the setback over here, has no setback at all for that matter. And we think that the Board of Appeals should grant a special permit to change that non-conformance so that we are at least 2 feet and 8 inches away from the property line over here. We have one lot line dimensional non-conformance here, a lesser one over here. The house is not to be changed at all as a result of this. We think that the Board of Appeals can grant that special permit under section 240-3. We don't think that any zoning relief is required over here. Yes, this house is presently closer to the street than 25 feet. And yes, there is a shed in the front yard, but those are existing nonconformances that are protected, and we're not changing those at all. It may be that the Board of Appeals wants to look at this whole thing as non-conforming and approve the entire layout under section 240-3. I'm not sure about that. And we're still dealing with the Board of Appeals about how to deal with that. So in summary, we're trying to solve a family's land use problems for its compound to allow the properties to be divided among the family. It's been in the it's now a second generation. It's some type of thing we're seeing more and more of. And there isn't an intent at this time to sell any of the properties outside the family, but we want to be able to solve zoning problems and divide it up. So that's it. I think that technically, believe this is an easy approval not required because we're not showing a subdivision. A subdivision is a division or redivision, as in this case, of land. But the division of a tract of land where each lot has the requisite frontage on an adequate road. We have a town road for CPIT that all three of the lots have at least 40 feet of frontage on, as well as these other old roads. So I think that this plan is entitled to A&R endorsement. Obviously, this is a more complicated plan, something we've been working on to figure out all the issues involved for over a year. And the town planner has indicated to me he would like to have discussion about it tonight and not ask you to vote on it. That's okay with us. This whole process has already taken a long time, and we do have a special permit that's coming before the planning board. We still have to complete a filing with the Board of Appeals. But I thought it was useful to get all the plans to the planning board so you can understand what we're trying to do. I'm happy to try to answer your questions.
Thank you, Bob, for your presentation. Can you make the screen sharing disappear so that I can see the members of the board and see if anybody wishes to ask it?
I can try to do that. I'm not sure what I'm doing here.
Okay, thank you. Yeah, does anybody on the board have any questions of Bob or any comments to make? Paul?
And Ms. Donovan, thank you for your explanation. I found this document a little confusing. It's creative engineering at its best. But will you tell me where the access will be in the future? For example, the lower lot formerly.
Well, the access presently to 108 CPIT is along Reed Path to that end of Reed Path. It was only 100 feet from CPIT that has that triangle at the end. We are proposing to eliminate the triangle as well, which doesn't add anything and really doesn't count as frontage. The Reed Path house, the middle house, is also accessed off of that driveway, off of Reed Path. Again, just 100 feet from CPIT. And there's a separate driveway for the 32 Nichols Road house off of Nichols Road. Now, all of the lots now will have frontage on CPIT, and the access in the future to 108 CPIT will be the same, but that Reed Path will serve only that house, although it also serves as the access to the adjacent property on CPIT Road owned by the Whalens. That's on the south side of Reed Path. There'll be a new driveway at some point, likely on CPIT to the middle house, the Reed Path house, and 32 Nichols Road will probably continue to be served by a driveway off of Nichols Road, probably the same driveway as exists today, though it would be possible to come off of CPIT. There are no impediments to driveway access to the lots from CPIT. And as a result, I don't think there's any issue about where the driveways would be or where they should be. But that's what we expect in the future.
Are there any other questions of Bob? Yes, Charlotte.
I don't have a question. I have an observation. It looks like an intricate but okay solution as you've described it. If we don't need further discussion, do we need to wait for another time to act on it?
Tom?
Town council and I and Noreen Stockman have all been talking about this plan. There's a lot of moving parts. And in talking to Bob Ament earlier today, I said we're working through some of these things, trying to get a better understanding of how they all work together. And it just seems like a lot to put your arms around for a first night out of the box with so many moving parts in the plan. So depending on the board's comfort level, but staff is looking at it going, it's probably okay, but we'd like to know more so that it's okay. To Bob's point about what is appropriate for A&R endorsement, what's appropriate for A&R endorsement is the frontage on a lot, on a way. Nichols Road is a subdivision way created in the 1926, and C-Pit is a public way. So there's not an issue with the frontage of those, but just the whole issue of reconfiguring lots and septic systems and just all the moving parts.
I just want to say that we're perfectly comfortable with cooperating with staff if they want to look at this in more time. I'm much more interested in the total picture. I'm confident we'll be able to get this A&R endorsement, but that alone doesn't solve the problem. We need the special permit from the planning board for the make it, and from the Board of Appeals. And I'm hoping just that as complicated as this looks, that both the boards will realize that it's a good solution for a family that has the 3 lots. And this is not, this is not a big new development. This is just, we're trying to solve old problems. And if it takes us a couple more meetings to do that, that's perfectly fine.
Okay, my comment is that at first blush, with Bob's explanation, I am now understanding this way better than I did just looking at it. And I see a large problem being solved by relocating the septic systems, or in one case, a cesspool. So it is protective of the wetlands. And although there are other nonconformities being put in, they're no worse than the nonconformities that are there, and they are solving some problems. Pam, you had a comment or a question.
I do. Bob, if all this is said and done, and it goes through the Board of Appeals and the site plan, the special permit, could one of the family members then sell?
Yes, certainly.
Okay, so this really frees them up as well.
Well, right, because right now we have, we would have a failed septic system for 108, we assume, and no way to install a conforming system. So we'd still be able to upgrade the septic system, but the standard under Title V under that circumstance is what's the maximum feasible compliance? And it will be far from a Title V system, but it will still be allowed. It's much better to be able to put the Title V system in, which is what we're going to do. So yes, we could sell that lot, but with that issue. But the other 2 lots arguably are unmarketable right now because the house, the middle house, is straddling the line.
2 properties.
Yeah, one could cut off a portion of the house, but it's an old 1-story house that's the family loves and is quite old, and they can't do that really on the south side, which is where we're going to need the Board of Appeals special permit, because that's where the kitchen is, and the house just isn't. It doesn't make sense to to rearrange the existing house, one would end up building a brand new house, and it would be a very different. Then there wouldn't be any need for any zoning relief. And it isn't what the family wants to do, and I admire them for wanting to keep the old house.
Right? Okay, so I would not be at all comfortable moving ahead tonight. I want to see what, I agree. This is going to take a little bit of work and understanding, so I'm going to support waiting until we get some more final. Well, also, we have to hear from the Board of Appeals.
No,
No, that's not true.
us first.
Never mind. Or wait a minute, I should do it this way. Never mind.
Jim?
I spent the better part of an hour and a half studying it, and I understand it now. So I'm ready to go ahead. There is an awful lot of moving parts, and and Bob did a really good job explaining it. But that's a complicated plan. Everyone, I like it. I'm ready to do it whenever the other board members want to do it.
I'm ready.
What about John?
I'm ready also.
Anybody else ready to go with it
Yes.
tonight?
Same here. It just seems like there are so many moving parts. If we could alleviate the process by taking care of one of those moving parts, as long as it doesn't have an impact or impede one of the other moving parts, I'd be all in on going for it.
Anybody else? Yes, Paul? Paul, I can't hear you for some reason. I don't see that you're muted, but I don't know what's going on.
Needs to turn up his volume.
Okay.
There we go.
You're better. You're still not loud enough. Can you get closer to where your microphone is?
Now can you see me?
See you and hear you just a little better.
Okay. I think there's a lot of creative engineering here. I think it's a fine solution. I would have liked to have seen the 2.8 foot space from the existing house to the property line. But that's a very minor issue. I don't see any reason to hold this up. I'm ready to move on it.
Okay. Seems like the board is all in favor of moving ahead to do an approval not required for this plan. May I have a motion, please?
So move.
Is there a second?
Second,
It's been moved and seconded. Any further discussion? May I have a show of hands, please? Okay, that's all 7 of us then. Thank you. Thank you, Bob, for being very clear in your description of it.
Thank you. See you on the special permit.
Okay. Okay, next on the agenda, the applicant is William Fender. Plan of land to divide one lot into 2 lots located on Lewis Neck Road, map number 4003001B000B, Falmouth Engineering.
Thank you, Madam Chairman. For the record, Michael Borselli, Falmouth Engineering. I hope you can all see and hear me.
yeah,
Ken,
And with your permission, I'll share the screen.
please.
Hopefully you're seeing a plan of land for William Fender. We have submitted a approval not required application to create 2 separate lots on Lewis Neck Road. Each of the lots has adequate frontage, which in this case is 100 linear feet. Each has adequate area, 40,000 square feet. Each lot has over 42,000. And adequate lot width, which is 100 feet in this zoning district. There's currently on what we're designating as Lot 2, a single-family dwelling under construction. We've shown that on the plan to demonstrate that creating this lot in between Lot 2 and Lot 1 provides adequate setbacks, side yard setbacks 10 feet, and in this case, the building is almost 36 feet off the property line. There's a buyer for this house. Mr. Fender would like to get an endorsement so that he can deed out a portion of the land to the buyer. You will note that Lot 1 is noted as not a building lot, even though it has adequate frontage, lot area, and lot width. There's a question which you're all very much familiar with, access determination. Mr. Fender has prepared a plan to improve Lewis Neck Road. And at this time, since it's not improved, on the advice of your town planner, we've designated this as not a building lot until such time as Mr. Fender convinces you and you can make a determination that there's adequate access to create another building lot. At that time, we come back and remove the designation as not a building lot. So that sums it up, and I'm happy to answer any questions.
Okay. Paul?
Yeah, Mr. Roselli, I noticed on the lot north of there, parcel C, there's a easement that terminates at the property line.
Yes.
Would you explain what that means?
Well, I believe that the abutting lot had created an easement for utilities and some future road widening that they did not, they have not yet exercised rights within, but it designated an area on the frontage that was available to either install utilities or widen the road.
Thank you. That has nothing to do with this project.
It has nothing to do with this.
Okay, now I can't see anybody else on, thank you. Does anybody else have any questions? Jim?
I did have serious questions about the adequacy of the road, but Mike pointed out, I did not catch the label that you've labeled the other lot not buildable. So that solved all my issues. I didn't notice that until you pointed it out.
Okay, are there any other questions or comments of Mike? Okay. So this is another approval not required. Yes, Charlotte?
Move to endorse approval as presented with the lot Upper House plan, not buildable.
Okay. And normally when we endorse an A&R, we do it without regard to buildability and zoning. Yes, okay.
Thanks.
So that note would also be on it, on our decision.
I second.
Jim?
I
Okay,
second.
so it's been moved and seconded. John?
A question?
Yes.
As you said, A&R plans always show no regard for buildability, but one of these two lots is already built on. So I think we have to adjust what is going to be said on this A&R because both lots are included in A&R, not just one lot.
How would you adjust what we're saying?
The lot 2 is not buildable until the planning board determines the access is adequate.
Okay,
Because in this case, the building commissioner determined that the access was adequate for the houses being constructed.
okay. Actually, it's not, lot 1 is the one that has the not buildable.
I couldn't see which lot it was, but the
It's
one
lot
that's not
1.
going to be built on.
It's
Lot
lot
2
1.
is already being built on.
Lot 1 is the one designated not buildable.
Mhm.
So we have to make some kind of a notation on the plan that says that that lot is not to be built upon until determination by the planning board of access.
It says that.
But that should be in our A&R decision is what John is saying.
Yes, because otherwise it'll say it for both lots. If it says it on the plan, it'll show both lots. And one lot's already buildable, obviously.
Tom?
Yeah, I think that's a fine note to add to the plan. It's sort of a belt and suspenders from what there, but just to correct the record, the planning board actually did a determination of access for this lot, much like they did for Falmouth Housing Trust.
Yeah,
And the entire lot is buildable with the same improvements that Falmouth Housing Trust did for their lot. Any further work would have to require a new determination of access. So the building commissioner issued a building permit after the planning board's determination of access and after Mr. Fender made those conditions on the ground of clearing back trees to 20. So determination of access previously, a new determination of access before the note gets removed. But John's note, I think, is perfectly appropriate. And it was fine with the mover in the second, not an issue from my perspective.
Thank you.
Any other comments or questions? Okay, we do have a motion before us to grant an approval not required on this lot. The lot with the note that John proposed that lot 1 is not a buildable lot at this point in time. Okay, and I assumed Tom will put the appropriate words to it, but the sense of the motion is that.
I have lot 1 is not buildable until the planning board determines access.
Okay. So it's been moved and seconded. Please show your hands. Okay, all 7 of us. Thank you, Mike.
Thank you.
The next one we have is again another approval not required. Jeffrey and Barbara Lintner, plan of land to divide 2 lots into 4 lots located at 72 and 78 Benjamin Nye Lane, Falmouth Engineering. And we have Mr. Lintner with us.
Can we bring Mr. Borselli back as well, please?
I would like to. Okay, and Mr. Lintner,
I
do you
thought it was
wish to-
something I said.
do you wish to show yourself, Mr. Lintner, or just listen in? There you are. Okay, thank you. You're muted, so we couldn't hear you.
I'm going to take the lead, Madam Chairman.
Please,
I'm
Mike.
happy to have Mike take the lead. Thank you very much, Madam Chairman.
Okay, thank you, Mike.
Thanks again, and for the record, Michael Borselli, Falmouth Engineering, and I am joined tonight by Jeff Lintner, the property owner. The property is that the Lintners own is on Benjamin Nye Lane in North Falmouth. It actually has some frontage. I should share my screen, I suppose. How's that? Am I not sharing?
Well, you're starting. Okay, now we've got it.
Okay, so the Lintners own the property, and it has significant frontage on Benjamin Nye Lane. It has some frontage on Wild Harbor Road. And they own approximately 6.5 total acres of land. It's been in the family for a very long time. There are existing dwellings located on this portion of the land. And there's a house number 72 located over on the far southeast corner of the land as well. And the remaining land is undeveloped. So we're here tonight in hopes of getting your endorsement as approval not required. This lot is in residential B district with a minimum lot size of 40,000 square feet, a minimum lot width of 125 feet, and a minimum frontage of 100 feet. We have accomplished all of that with frontage on Benjamin Nye Lane. Benjamin Nye Lane, I think you'd all agree, has adequate access. It's a paved double-laned road that leads from Wild Harbor Road, and it connects through to Old Main Road further off the page to the east. So each of these lots has adequate frontage, lot area, and lot width.
Okay, Any questions for Mike? And again, Mike, I can't see if anybody might be asking questions.
Sorry about that. There you go.
Okay, does anybody have any questions for Mike? I have one, Mike.
Sure.
On Lot B, it says driveway easement for Lot C, but
Yes.
I don't see where that might be and why it would be necessary.
Okay, that's a good question. So I've zoomed in on that. Lot C is just south of Lot B. You can see the designation here.
Mhm.
There's a dashed line here, and there's a dashed line here. So this entire area is designated as a possible location for a driveway easement that would serve Lot C, where if the owners of the land agreed that a common driveway was better to serve home sites on Lot B in this area and Lot C in this area, it would eliminate the need for an additional curb cut on Benjamin Nye. The concept would be that the existing driveway, which is here, that leads to,
Mike, I'm going to interrupt you. I can see what you're talking about, but you're not screen sharing anymore. So,
oh, that's right.
yeah,
I gotta remember.
but I can see on mine what you're talking about.
Well, I was demonstrating with my mouse all over the place. No one
Of
could
course
see.
you were, but I can see the dashed lines
right.
and I can understand that if it's
Yeah.
a shared driveway easement, the topography.
Yes, it helps us avoid this ridge. I mean, we could build a driveway here, but we'd rather not. And the Littners want to keep Benjamin Nye Lane just as a lane and have less curb cuts, less pavement, less driveways. So the idea would be to have a driveway easement to the benefit of Lot C over Lot B to gain access to where the home site would be back here.
Okay. Does anybody else have any questions or comments of Mike? And again, I can't see because this is a very difficult thing
How
here.
about that? There we go.
That's better. But does anybody have any further comments of or questions of Mike? Okay. It looks like then everybody is okay with this, and so I would need a motion.
So move.
Second,
Been moved and seconded that we accept and endorse an approval not required plan without regard to buildability. And I always forget the rest of it, but the standard wording on it. Is there a second? Oh, there was a second to that. Okay. All in favor, please show of hands. Okay, we're all in favor of it. Thank you, Mike, and thank you, Mr. Lintner.
Thank you very much and have a good evening.
You too.
Thank you, Madam Chairman and group. Appreciate it.
Okay. We move on to a planning board decision. The applicant is SCS Nathan Ellis 011282 Falmouth West LLC and SCS Nathan Ellis 011282 Falmouth East LLC. Site plan review application to construct a large-scale ground-mounted solar carport facility. And we do have the decision in front of us. Would somebody like to read it? Bob.
Okay, draft, August 25th, 2020. Motion that the planning board vote to approve the application of SCS Nathan Ellis 011282 Falmouth West LLC and SCS Nathan Ellis 011282 Falmouth East LLC under Article 47, large-scale ground-mounted solar overlay district of the zoning bylaw for a plan entitled Cape Cod Fairgrounds Solar Carport Project, Site and Civil Plans, 1220 Nathan Ellis Highway, East Falmouth, Mass. 02536, prepared by TRC Companies, Inc., dated May 20th, 2020, revised August 3rd, 2020, scale as noted, sheets 1 through 24, along with Falmouth site plan review, filing entitled Cape Cod Fairgrounds Solar Carport Facility, 1220 Nathan Ellis Highway, East Falmouth, Mass. 02536, prepared by TRC Companies, Inc., dated May 20th, 2020, revised August 6th, 2020, sheets 1 through 409, as well as stormwater report entitled Cape Cod Fairgrounds Solar Carport Project, prepared by TRC Companies, Inc., dated May 20th, 2020, revised August 2020, sheets 1 through 24, with the following findings and conditions. Findings: the applicant, SCS Nathan Ellis, 011282 Falmouth West LLC, and SCS Nathan Ellis, 011282 Falmouth East LLC, is seeking to construct a large-scale ground-mounted solar carport facility located at 6 parcels located at Assessors Map 18020030000, 1802002, 185, 1802002, 184, 1802004, 1802006, 180030001, 6 parcels totaling 37.3 acres are located in AGA as the underlying zoning, as well as in the solar overlay district. The parcels are also located in the coastal pond overlay, Wacoit Bay, and in the water resource protection district. The applicant is proposing to construct approximately 7 MWDC solar photovoltaic PV carport facility at the fairgrounds, 5 parking lots, and 1 existing RV lot on both sides of Nathan Ellis Highway. There are currently no structures existing, and as such, the town planner and the building commissioner have concluded these newly constructed structures will be deemed ground-mounted arrays as carports. The solar PV carport structures will be supported by an I-beam, and the structures will be approximately 19 feet 4.5 inches to 22 feet 9.5 inches high, and the overall footprint of the roof will vary depending on the parking lot configuration. The lots being proposed are existing parking lots. Gravel will be placed under the arrays, and the area outside the arrays will be left as grass. No paving is proposed, and the parking capacity will not increase. Minimal tree clearing is proposed, and no work in wetlands is required. For the applicant as submitted through an email from Jonathan Eidman, Chief Regulatory Officer for the Cape Cod Commission, this project does not require a mandatory development of regional impact (DRI) review because it does not constitute a change of use. The Department of Public Works Engineering Division referral dated July 1st, 2020 outlines open comments from reviewing applicant's site plan. The applicant's engineer submitted revised plans dated August 3rd, 2020 in response to the town engineering comments. The planning board finds that the applicant will submit a financial surety in the form of a decommissioning bond pursuant to Article 48, Section 240, 255C in the case or abandonment or need for decommissioning. The planning board's review does not include building code review, and the board defers to the building commissioner as to issues related to building code. The planning board would like to thank the applicant for revising plans and elevations based upon board review and comment. Conditions: the plan shall be constructed as approved. Any changes shall be reviewed by the planning board to determine if modification of this decision is necessary. Pursuant to Section 24183B of the zoning bylaw, no permit for full or partial occupancy shall be issued until the planning board is satisfied that the conditions of this approval have been met. 2, the applicant shall provide a financial surety to the town in the form of a decommissioning bond pursuant to Article 48, Sections 240, 255C in the case or abandonment or need for decommissioning of the large-scale ground-mounted solar photovoltaic project. 3, the applicant will, at the time of building permit submission, submit a landscape plan. 4, prior to installation, the applicant shall file with the Traffic Advisory Committee for approval of the proposed crosswalk across the Shumet Road. 5, construction of this project shall follow the attached soil erosion and sediment control standard conditions document. References to the Department of Public Works Engineering Division shall be replaced with the planning board, who is the permitting authority for this project.
Is there a second, please?
Second.
Okay, it's been moved and seconded. Is there any discussion on this decision? Paul?
I have one quick question. We had a lot of discussion about the landscaping, the last meeting we had, and I thought there was some pretty good ideas. And this condition says the application, submit a landscape plan. Doesn't say whether it's coming to the planning board or who's going to review the landscape plan.
Tom?
I would be reviewing that on behalf of the board. If the board would like to see a landscape plan that comes back, but we were just talking about not fully landscaping the entire site, but some of the walk areas. So it seemed fairly minor. We talked about a landscaping plan, use in indigenous plants and xeriscape type plant. We didn't have need for irrigation and things like that. So I would be doing the landscape plan when it was submitted. If the board would like to see it, absolutely.
Paul?
Yeah, I suggest we add for, at the end of number 3, add for administrative approval. Doesn't have,
Okay, so you want to add for administrative approval?
yes.
Okay, so this is, yes, Tim?
Yeah, I just have a question for the town planner. When I looked at this plan, it looked like one of these things had a 90-foot steel beam, and are we still calling it not a structure? I have trouble with that determination. I heard that language. This is 90 feet wide, concrete footings and steel, and it's not a structure.
I am familiar with your concern, as is the building commissioner. They're carports, they're ground mounted solar. That to me is a structure.
Yeah.
Building commissioner doesn't consider them as such.
Okay, I disagree with that interpretation. I just want to go on record with that, but I'm still going to vote for this plan, but that's got to be fixed.
But Jim, in the decision, it says newly constructed structures will be
But the-
deemed as carports. So this definitely says these are structures.
So they are saying they are structures.
That's how we're approving it. That's what the wording is of
Oh,
the decision.
please withdraw everything I just said. That's what I wanted them to be, is called structures.
We'll do a
Okay.
never mind for you, Jim.
Never mind.
Okay. All right. So we have a motion. We have a slight addition, and I don't know that we need to call it an amendment to the motion. It's adding a few words for administrative approval. Do you all agree with that, I think?
Yes.
Okay. So we have a motion and a second. All in favor, signify by raising your hand. Okay, 7 out of 7. Thank you. And thank you for coming tonight, Mr. Friedman.
This is a good project for the town.
It really is, yes.
Thank you all very much. Appreciate your time.
Okay, public meeting, applicant, Woods Hole Partners LLC, definitive plan application to create a 4-lot subdivision with 445 linear foot roadway located at 533 through 539 Woods Hole Road, Cape and Islands Engineering. And we do have some comments that came in. I'm trying to find them. As you can imagine, we've had comments before.
Madam
And-
Chairman, I'm recusing myself.
Okay, thank you. And Paul?
Yeah, I don't have the information on the notification. Perhaps Tom can indicate that.
I think this is just a continuation, right, Tom?
Right.
This is a continuation of what we've already
Yes, ma'am.
been over, which is why you wouldn't have any notifications, Paul.
This is the continued hearing, correct?
Okay? It's been, I understand that there could be confusion because it's been much delayed. And Mr. Ahmet, Bob is here to go over things with us. Oh, and so is Matt Costa. Hello.
Matt Costa is here as well and can tell you what changes were made since before the previous hearing where this was further continued. And I also believe that Michaela Shoemaker may be prepared to make a report on the status of this based on my conversation this afternoon with Tom Bott.
Okay. Yes, Bob.
Could you check the chat? We have someone in the chat.
Tom or Michaela, who's in the chat?
Yes, that'd be Dr. Epstein.
Okay, and I do have his written comments here.
And I'm prepared to address both his question in the chat as well as his earlier email, if that would suit the board.
Do you want to preempt the discussion by Bob and Matt and do that first?
Whatever works for the board.
Okay, Charlotte, you had a question?
Yes, Tom, could you refresh my memory and maybe the other board members, how often we've had this hearing continued? Seems we have seen this a lot.
This hearing's been continued a couple of times and largely because the capacity of the in-house staff to review some of the technical aspects of this. This is a request for a subdivision approval in order to grandfather the zoning on the property.
No, I recall what we're doing. I just wondered how often we've done it.
I don't have that information in front of me, I'm afraid.
I think it might be informative if Tom speaks to Dr. Epstein's concerns because he sent in 2 emails. I believe they were both today. And Tom, don't you think it would be informative because then Bob and Matt could perhaps answer some of his concerns?
I'd be happy to.
Okay.
In the chat, Dr. Epstein requests, I wish to be seen in caps and heard in commenting on the Woods Hole partner proposal in addition to my emailed comments. My comments will be more brief than my emailed comments. Earlier today, we received an email from Dr. Epstein as well to the planning board that I forwarded to town council. Dr. Epstein's comments at that time at 11:58 today were to the planning board with regard to online meetings. You cannot allow the representative to a project to remain on camera while not speaking. Other attendees who have been given the same privilege of appearing, and it is unfair to allow a given speaker's expressions and body language to editorialize about other people's comments. Further, anyone who wishes to speak must be allowed on screen time. Not that I wish to run an inherent, not to do so is to run an inherent unequal meeting and render suspect, if not invalid, the business of the meeting. I have written the Falmouth Select Board on this point twice. While I believe everyone involved is trying to act in fairness, past meetings have failed on these points. Past meetings have had attendees who have not been recognized by the chair, whose responses and comments have gone unentered into the record. This deprives the board of the very purpose of a public meeting. Meeting hosts must work to present all views equally and prevent given speakers from retaining the floor when they are not addressing the board. So as I said, I forwarded this email to town council earlier today. Council's reply was, I understand that the planning board is following the same procedure as other boards with online meetings. The procedures are not perfect, but under the circumstances are not inherently unfair. Before the pandemic, many boards accepted written comments for the record. No person spoke. At a real-time meeting, the applicant remains in the room, often in the front row, and body language and facial expressions can be observed by anyone in the room. From my experience, most board members are skilled at filtering out the distractions and the noise and focus on the relevant facts. Considerations must be given to temporal issues, period. It takes longer to conduct business during an online hearing than real-time, and procedural adjustments are necessary and prudent through town council. So as we said before, this is one of the more imperfect things about meeting on Zoom. However, it's oftentimes there is someone in the room who puts their hand up to be recognized by the chair, and it's up to the chair to recognize them. The process we've held is to have those comments recorded through Zoom. And in addition, we also have Dr. Epstein's comments that I'll be happy to read in at the time the chair dictates that they'd like me to on the particular technical aspects of this matter in front of the board.
Well, they're quite lengthy. We could perhaps do a summary of them, do you think, Tom, or not?
I will read them verbatim if that's, and that is as I think they should consider.
Okay, that's fine. Because I think that with his comments, I do believe that we should allow Bob and Matt to respond. And I think Mr. Epstein would appreciate perhaps the response to those comments too, as well as what we're about to hear from Bob and Matt.
One moment, please.
And he just chatted us, yes, I will appreciate their comments. So I think, thank you.
All righty. August 25th, 2020, to the Planning Board regarding Woods Hole Partners, 533 Woods Hole Road, seeking a subdivision permit. Do not allow this, period. The developer has admitted that their own reasons for doing this is to freeze or grandfather the special permit granted by the Zoning Board of Appeals, which would allow an increase in density from 6 units per acre to 8 units per acre. This special permit remains under challenge in court, and you should not vote on this until it is resolved. Further, that the developer wants to freeze their allowance for higher density only confirms that this is a misuse of business redevelopment zoning, quote, solely for economic benefit of the owner, end quote, of this parcel. This is clearly spot zoning, which is illegal. Town of Falmouth clarified their position on third stories with respect to square footage in November 2019, at least partially in response to the exception that had been issued to this very developer on this specific parcel. The town made it crystal clear that third stories cannot include more than 50% of the square footage on the floor below it. Making yet another exception for this developer on this parcel only strengthens the case that the town is allowing spot zoning for the benefit of the specific developer on this parcel, quote, solely for the economic benefit of the owner, end quote. There is absolutely no reason to allow this one developer to have yet another permit to freeze in place what the town so clearly has recognized is a problem and is moved specifically to codify by disallowance. Further, the business redevelopment zone is again used in the most shadowy of ways here. The opening statement of the BRZ reads as following. Purpose. Purpose of this article is to promote the revitalization of commercial centers using mixed-use development, integrating retail, office, restaurant, and community service uses with housing, such as second-floor apartments, condominiums, and townhouses. This redevelopment fosters pedestrian-friendly streetscapes by requiring rear and side yard parking, allowing shared parking between the businesses and uses, reducing and consolidating curb cuts, and allowing parking reductions in exchange for on-site green space. The district also relaxes front, side, and rear yard setbacks to encourage sidewalk development and pedestrian-friendly storefronts to offer street-side gatherings in front of places of redeveloped property rather than front yard parking fields. The developer is attempting to exploit this zoning to build dense condos, which have nothing, that is in caps, nothing, to do with the mixed use and are solely, and that is in caps, solely residential in order to seek a special permit for increased density. There is no mixed use here. There is no shared parking between businesses because there are no, and those are in caps, are no businesses. There is no, quote, pedestrian friendly, unquote, storefronts, period. That's a period written as period. Don't get involved with the developer's attempt to ram through wrong zoning by twisting the words and ignoring the very intent of the zoning. BRZ was conceived for Main Street, Falmouth, where apartments might be built above stores. The developer's attorney has tried to reverse engineer the language of the special permit to get the zoning board to approve the greater density. This is like someone saying, quote, "Don't kiss me," exclamation point, end quote. And the developer saying, "Oh, you used the word kiss, therefore I may kiss you," end quote. Under special permit, the Falmouth, under special permit, the Falmouth Code reads as follows. Special permit uses, (1), uses allowed on special permit from the boards of appeals. B, multifamily use greater than 6 units per acre, up to 8 units per acre if, and that is in caps, if the Board of Appeals finds that the public good will be served and the business zoned area would not be adversely affected and the uses permitted in the zone would not be noxious to a multifamily use. There is wording provided, quote, that the business zoned area should not be adversely affected, end quote. There is no business here whatsoever. and strictly residential, and the zoning has only been applied, this zoning has only been applied, and the special permit considered again, quote, solely for the economic benefit of the owner, end quote, exclamation point. The planning board should reject this proposal because it goes against the expressed interests of the town to not, that is in caps, not have the third stories in the residential buildings. To approve it will only make clear that the town of Falmouth is catering to this specific, and that is in caps, this specific developer's manipulations of the bylaw and allowing unconscionable greed. Planning board approves this permit, it is tantamount to saying that this, and that is in caps, this developer is special, and that this developer's project, yet again, does not have to abide by the town's own stated laws. Further, the planning board approves this permit, which the developer admits they have no intention of ever building. It is a recognition that it is the function solely to freeze the erroneously applied BRZ. Thus, the planning board will be endorsing a reduced parking requirement that will be a problem forever. Falmouth Residential Code permits 2 parking spaces for every dwelling having at least 2 bedrooms. The developer of this project plans 43 units with 48 parking spaces, 6 of which be slated for use by the Dome. Thus, there are fewer than 1 space per allotted dwelling unit. Such over-dense development will result in people parking on adjacent streets and struggling to place their own cars somewhere, let alone those of any guest. To the planning board, this project is so fraught with problems, being kicked down the road with a vague future, that to allow it will forever stand as a mistake. Reject it, table it, send it back. You're not voting on a subdivision plan. You're voting to freeze the previous zoning, which you yourself corrected in the 2019 clarification that all, and that is in caps, all 3-story must conform, 3rd stories must conform. The zoning on this property is still being challenged in court, and in any case is a travesty of planning that the town of Falmouth would do well to disentangle itself from. Don't reaffirm the spot zoning that has been given to the developer on this parcel by yet again giving him another exception to the rule solely for the purpose of freezing in place a full 3rd story, even after the town had specifically prohibited this. Sincerely, David Epstein, 15 Fern Lane.
Thank you, Tom. And he thanks Mr. Bott for a good reading of his letter. He does not need further screen time to present his comments. Okay, so I would like to then turn it back over to Bob and to Matt. They can answer Mr. Epstein's comments as they desire, but also to go ahead with their presentation. And I appreciate your indulgence, both of you. Thank you.
Well, let me save Matt the trouble of replying to Dr. Epstein. On behalf of the applicant, I disagree with almost everything that Dr. Epstein has just said. Many of his propositions are the subject of a pending court case, which is into discovery, depositions, and the like, and those are for the court to decide. But they have to do with the special permit that has already been granted by the Zoning Board of Appeals. Special permit with some similarity to what was approved by the Board of Appeals in around 2008. But I'm not going to go into the merits of the project that the owner plans for the property, which has been, as I said, approved by the Zoning Board of Appeals, and also pursuant to site plan review by the Planning Board. Because what's before you has almost nothing to do with that project. Anyone intending to develop these 5.4 acres for any use in the future would be smart to take advantage of the state law, which allows the zoning to be frozen, as we're doing. The fact that it requires a submission of a subdivision plan makes it, I think, in most people's mind, a rather odd and cumbersome legislative decision. But that is how one puts the zoning in place. Perhaps in order that we can have a project in the future that is more like what Dr. Epstein would like to have, perhaps. But this has nothing to do with the previously approved project. It allows that any project in the future could be have 3-story buildings. As the town determined, applied at the time that the approved project was approved, and at the time that we submitted the plan that's before you tonight. So that's all that's before you tonight, is the division of this 5 acres into 4 lots, one of which has its frontage on the Woods Hole Road. It's a short road serving 3 lots, which might be developed for a number of different uses, perhaps pursuant to different zoning in the future. But simply ask that you approve the plan as you indicated you would do with when the preliminary plan was voted, and grant the waivers which you indicated you would grant when the preliminary plan was voted, and which are perfectly reasonable in the circumstances, particularly since the proposed road follows the driveway and uses the curb cut that served a 56-unit motel, and I think it was about 174, I may be wrong on that number, seat restaurant for decades. With that, I'd like Matt just to review how his latest plan responds to concerns that were raised by the engineering department, and what the waivers are that we'd ask that you grant. This plan has been before you for a long time. This is not a situation where we've had too much angst about prompt approval, because we don't intend to build this road. On that, Dr. Epstein is correct. But every time Matt and I have to come, and every time he changes the plan, it is an expense. And we're hoping that we're close to getting a vote from the planning board on this matter. Maybe Matt should weigh in now.
I know there were requests from the planning board to Matt that he answered the last time, but we didn't have enough time to see it at that point in time. So please go ahead, Matt.
Thank you. For the record, Matt Costa, Cape and Islands Engineering. Yeah, so the last staff report from the engineering division was July 8th. And that had a couple of open comments. And our latest plan revision that was submitted shortly after addressed those comments. The open comment specifically was calculations related to the size of one of the drainage pipes. We revised it to make sure that the calculations in the plan matched up. There was an open comment still that was left over from our original letter that was prepared June 11th. So to give you a timeline, we had the first engineering staff report. We prepared our letter June 11th. addressed those items, identified some other waivers that were being requested as part of those, and I can go through that. We then received a response from engineering on that on July 7th, July 8th. And we submitted the most recent plan that you have. There was one sheet that needed to be revised to address the open comment. So his first open comment was the 305-24, which had to do with the size of the pipe. So that's been addressed. The 305-42, he goes on to talk about, this was one we had asked in our June 11th letter for the board to not adopt that requirement. And specifically, we requested, this has to do with inspections at the time of construction. And we're requesting the board not adopt that because it does actually say specifically in subdivision control that the inspections would be done by the town's appropriate department at no cost to the applicant. So in this instance, we have a staff report and we've been held to every letter of the law of subdivision control, and we've had to request a lot of waivers that we've traditionally never requested before. But in this particular case, that letter of the law says that there shouldn't be a charge for the inspections. So that's why we were requesting that the board not adopt that. Then there was talk about his third open comment was a street light being added. We were proposing a street light be added to one of the existing utility poles that are there near the entrance. We're flexible if the board would like to see a street light closer to Woods Hole Road. That existing utility pole should cast enough light on that entrance, in our opinion, but we're flexible on that if the board would like to see something different. And that's what he essentially says in that report. Everything else is just reiterating what was addressed and then the waivers that we were requesting and then what comments were closed. So I won't go through all that. And just to run you back over the waivers that we're requesting a series of those. Some are really closely related. Some have to do with the generic cross-section of a roadway. And we vary from that depending on site conditions. And in some cases here, we need to vary from that generic profile. So we're requesting a series of waivers that are related to that from 305-24, the roadway cross sections. We're requesting waivers for sections 305-24, 30, 35, 37, and 40. Those are all outlined in our June 11th letter. There was one thing that was brought up in engineering staff report that we didn't request a specific waiver for because it was a question I think he had to you if that was necessary, and we kind of have the same, and that is under section 305, 41, and 28, and that has to do with fire suppression. It was his understanding, it's our understanding the town didn't require that anymore. So I actually didn't request that waiver in the letter for sections 41 and 28. If the board thinks that's something that we should request, we can do that. But everything else is outlined in the letter, and the most recent engineering comments have been addressed with the new plan that you have that has been submitted. So hopefully I was clear, and I'd be happy to answer any questions.
Thank you, Matt. Does anybody have any questions of Matt? Okay, and I think, Bob, you had indicated that you've been talking with Michaela and she might have something to add. Is that correct or not? Did I misunderstand?
Yes, actually, that was my conversation with Bob today. I asked Michaela to give us sort of an update of the status of this because there's been a number of reports back and forth that Michaela has been following for me. So with that, I'll turn it over to Michaela for an update on where we're at in the process.
Great, thanks, Tom. Michaela?
Hi, Pat. Hi, everyone. So Matt actually did a great job of outlining kind of the back and forth between engineering and the applicant, who has been very responsive. So engineering actually did kind of a final review last minute today, just for us, and there's no open comments remaining. As Matt outlined, they've gone back and forth, and everything has been addressed thus far. So that's really the update that I had. Matt, you kind of did my job for me tonight.
Okay. Thank you. And the board seems to have no further questions. Yes, Bob.
Yeah, just, I guess, historically, what was the previous zoning of this property?
You mean before it became?
Before it was business
now.
redevelopment?
Oh, I believe it was residential C,
Okay,
but of course it had for decades and decades, the pre-existing use actually was a special permit use, because as you know, commercial accommodations are allowed in residential districts, and with the with the motels, restaurants would have been approved. So anyway, that's the history. There was, by the way, as you know, a covenant with the Woods Hole Community Association, and when the property was rezoned to business redevelopment, that covenant, subject to town zoning, of course, allows the developer to do anything that they could have done in the RB, in the residential C zoning district.
okay, that's what I thought, and that's what I wanted that to come out tonight, that was the case.
There are a lot of uses potential on the property, particularly considering all of the different community service uses that are possible.
Yeah.
I'd like to point out the comment that Dr. Epstein has posted on the chat just now. And
If I may, it's typically the staff that reads those chats into the record. So if I may.
Of course, Tom.
So to Dr. Epstein's point, I thank you, Mr. Bott, for a good reading of my letter. I do not need further screen time to present my views. There was more beyond that. That is not all that's before you. The approval of this permit has the effect of enshrining in permanence the special permit which remains under investigation in court. There's nothing wrong with the plan per se, but there is something wrong with the residual effects of issuing approval. To do so codifies a special permit that is still being challenged. Period.
Okay. And Bob, you wanted to respond.
well, I'd simply say, of course, if the court were to decide for Dr. Epstein, then that would overturn the special permit. But what I wanted to direct your attention to is that Dr. Epstein is saying he doesn't have any problem with the plan per se, and that's what you're looking at, not the use of the property that's possible.
Okay. Thank you. Now, yes, Tom?
Can I just say one thing about the subdivision process and freezing zoning? This is a provision of that it's allowed under state law. In fact, the state law essentially says that a subdivision plan shall be approved. If a board denies a subdivision plan for any number of items, when those items are resolved, that applicant can come back before the board and have the plan approved. Essentially, state law does not have a provision to deny a plan. The board can deny one, list the number of reasons why it's denying it, waivers not given or something like that. And when the applicant comes back and meets those requirements, the board is basically directed by state law to approve the plan. We know that this entire permit is about freezing the zoning. So the longer that we have this discussion about what we're doing, and I'm not calling for the board to take any immediate action, as you heard earlier tonight, I'm like, well, let's look at this thing. And the board went, I think it's fine. But if the board approves the subdivision plan and the applicant decides or the abutters decide to appeal that, and that goes to court, that simply buys the proponent who's trying to freeze their zoning more time, because the freeze of the zoning is from the date of the endorsement of the planning board. So if the planning board were to vote for the approval and there was no appeal within 20 days, the board would endorse the plan and the grandfathering would start from the endorsement of the plan. The board votes for the subdivision plan and it is appealed, and that goes to court as well. That just lengthens out the process for how long the grandfathering will be in effect, assuming that at some point at the end of the day, it comes out of the court as an approved subdivision plan, because for the most part, that's how the law is written. It's not written by folks like me. It was written a long time ago and it's had a lot of difficulty changing things in the zoning. So I just want to point out just the dynamics here. While people may not be happy with the subdivision process to grandfather the zoning, and while people have the right to appeal that zoning, that decision of the planning board, what that effectively does is just extends the amount of the grandfathering time over the 8 years. It's 8 years from the endorsement of the plan, but a plan can't be endorsed until all the appeals have been settled. I don't know if that helps anything, but just wanted to point out that's the mechanism in play here. Thank you.
Thank you. So what is the desire of the planning board? We can direct the staff to prepare a definitive plan approval. And remember, when you have that, it's going to have to be a supermajority of our board voting on it. And our next meeting is going to be September 8th. Or we can just continue this further and have further discussion on it. Charlotte?
I move that we direct the staff to prepare an approval, as you stated.
I'll second.
Okay, it's been moved and seconded. John, did you have a comment?
I was going to second it.
Okay, so we got a couple of seconds here. And so unless there's further discussion, may I see a show of hands directing the staff to? Okay, so there are 6 of us directing the staff. And I'm going to assume that with that, if it's ready for the September 8th meeting, that there will be a supermajority of us present at that meeting. If you cannot be at the September 8th meeting, please inform Tom so that we can continue it to make the decision later. Yes, Bob.
Madam Chairman, I may be wrong, and I'm sure Tom Bott will correct me if I am. But this is not a special permit, and I don't believe that a supermajority vote is required for the approval of the subdivision.
It's a
Am I
definitive,
missing something there,
it's a
Tom?
definitive plan. I thought that also required 5 votes.
A simple majority of the board for a subdivision plan.
Oh, okay.
We do so many subdivisions that are clusters that are special permits. It just seems like every subdivision plan is a supermajority, but.
Thank you,
Yeah.
Tom.
Thank you for your correction, Bob. I appreciate it. So we will see you then on September 8th for the decision.
Thank you. Good night.
Okay, good night. Next on our agenda, planning board discussion, comments from planning board staff on draft revisions to site plan bylaw. And at our last meeting, I had asked all of you to take a good close look at it. I don't know how many have done that and if you're ready to proceed with that discussion or not. John?
I would prefer if we could defer this one more meeting.
Okay.
It's just a lot. I haven't had a chance to really go through the whole thing.
I hadn't either until late this afternoon. I did see the work that Michaela has done, and I did look up our site plan review, and I think she's spot on with what we have to look at. So just a comment in regard to that, and I really would like to defer it till our next meeting. Is that okay with both you and Michaela, Tom?
That's perfectly fine with me. We're not proposing to put it on the warrant for town meeting, as we talked about last week. But I do want to just make that plug one more time for the need to amend our site plan, because that 1,000 square foot change is just an anomaly. I'm just going to share one brief picture if I could.
Sure.
This is some discussions that we had with the folks at Hui. This is the, I'm going to go with the Iceland dock. And this is a new building that they're proposing to do, demo the building that's on that, rebuild the dock with this structure here. It would not have anything to do with the planning board because it's not 1,000 square foot change of the site. Hui, as we know, is a Dover Amendment nonprofit, so we have limited site plan review. But until we amend our site plan, things like that, we're just, watching them go by. And that might be fine with the board, and they're not building this anytime soon. But this is just one of those examples of, where our bylaw needs quite a bit of work. But this one in particular is just so many things go by that we likely should be weighing in on that we're not.
Tom, could you flash that again?
No, I just closed it. Sorry.
But it's representative of the kind of thing that can get by without planning board review, without site plan review, unless we amend it to be lesser square footage, lesser parking area. And there were a couple of other things that were added in there too that we might very seriously consider putting in our bylaw. And I really do appreciate Michaela's research on this.
Yeah, we definitely need a threshold for what trips the threshold for site plan review. It's not everything, but that threshold has got to be something that's reasonable and I think more reasonable than what we've got now. But once again, my opinion is the staff.
Mm-hmm. Great, thank you. So we have future agendas for pending applications. Do we have? I think we do have something. I just don't have it in front of me. Tom, you're muted.
Sorry about that.
There you go.
Screen there. We do not have that for you, but we did forward to the planning board the list that was requested of accessory housing units. I do hope the board received that.
Yeah, I thought that was great.
Yes.
Yes, that was really helpful. Thank you very much.
Well,
I had no idea there were so many.
And well, one of the things that I talked about the staff about is, a number is a fine thing, a list is a fine thing, but I'm a planner and I like to see things on maps. So I like to plot those to get an idea of what our geographic distribution of these things are, just as an exercise in who are our takers.
That would be great.
Sewered, are they areas that are not sewered? Just to have a better idea of where our business is at.
Jim?
The existing GIS map plots all accessory apartments already. So you would like to differentiate between the new and the old. But once if it's an accessory apartment, it gets put on the GIS map as a little red house.
Tom, you're muted.
It's a little tough if you throw the entire town of Falmouth map up there to see where they're all at. But yes, there is that note on the GIS where there's an accessory housing unit, where there's a home business and those sort of things as well, correct?
Okay.
Jim, is that how you knew so closely how many there had been? Because you were just about right.
No, it's just I've been actively involved in every one of these things, commenting on it. I've been paying a lot of attention to it. I've kind of made it my goal to help get it done right. I mean, the bylaw was a little hard for people to understand. We had to teach them, but now it looks like everyone's catching on. The measurements going right. Everything's going well.
And when we had first done this bylaw, we had anticipated when people were objecting to it that we were going to be overrun. All the neighborhoods were going to be overrun with accessory apartments. We had anticipated we'd probably see 10 to 12 per year. And I think Jim said that's just about what we're seeing on average.
Mm-hmm.
So that's just the way it plays out. And honestly, I think we're fortunate to see the 10 to 12 per year. I think that means we're fairly successful with that bylaw. Okay. Announcements? Any announcements? Yes, Pam.
Our housing summit is going to be held, unfortunately, via Zoom, but nonetheless, on October 14th from 6:30 to 8 with 4 speakers. And I think, and I'm hoping people will tune into it despite how loathful it is to be on Zoom meetings every night. But anyway, we're hoping to have a good level of participation.
Great. Anybody else? Yes, Bob?
Habitat for Humanity has their kayak raffle that's being set up at the Restore up in Brick Hill Road. So if you're like to take a chance on a nice kayak and help out Habitat, we'd appreciate it.
Thank you. One thing I'd like to say is that Charlotte and I put together an initial introductory letter for the sending out of our recodification. And Tom has sent it out to the two Bobs and to town council to have a look at it and to add some legalese so that it's more prepared to go to a town meeting warrant item. Have I stated that pretty carefully, Tom?
Yes, ma'am. I just wanted to make sure that the language that will be used in the warrant for moving the recodification is consistent with what we're sending out now. This idea of a rewrite, of a reboot. I just want to make sure that there's no room between what we're saying now and what we're going to put into the warrant later on.
Yep.
It's complex enough as it is with all the parts that's to it. And we just want to make sure that we're all straight on that.
The anticipation is that it will be sent next week, assuming that everything is in place to do so. That's the anticipation. It'll be sent out, and all planning board members will get a full copy of it, not online. Tom?
Yes, I had asked previously if folks would be willing to suggest people who should get a copy of that. We're familiar with most of the folks who do permitting, attorneys, engineering firms, and things like that. But if folks would be happy to send me a list of those people who we may not be aware of that do this sort of work, I just want to make sure that everyone in the development community gets a copy of it to review prior to our meetings, which will likely start in November, the hearings for this. Because we've kind of got to get out of the woods of the Springtown meeting, which is still going on, and the November town meeting, this is not in. So if we launch the hearings too early, town meeting think we're talking about something for November. So right now the schedule looks like we'd open the hearings on this probably just past Veterans Day, which is, of course, the 11/11.
Okay. Yes, Charlotte?
Will the PDF of the whole thing be posted on the planning department's website?
A PDF of the whole thing will be posted on the planning board's website. I'm actually going to talk to the library about whether they would be happy to curate a copy for us as well, assuming the library could be open one of these days. Usually we've got, larger copies of things like that available in other places, but the PDF is what we'll be sending out along with the crosswalk so people understand what changed and what switched. So I want to have it on every device I can to make sure that we're putting that information out there for as many folks as possible.
Great, thank you.
As you can imagine, all of that takes time and a lot of effort from our planning staff,
I
which
realize
I
that.
greatly appreciate.
Well, so does the copying to give us our mail.
I know.
Which I really appreciate. So
So
thank
do
you
I. Yeah.
to Melinda and everyone who's working on that. That's really helpful.
The only general correspondence that I was aware of was Dr. Epstein's. Was there anything else that I'm not aware of?
None that I'm aware of that you're not aware of.
Okay. And we talked about the future agenda items because that's up under planning board discussion. And with that, is everybody ready? Yes, John?
I just want to either ask a question or make a comment that when we met in person, we had A&R plans, we would all get to review them at the planning office. And it was very seldom that we took any testimony, if ever, from an applicant or a representative of the applicant. And tonight we had two A&R plans where it was handled like it was a regular subdivision plan. Testimony from the engineer, and in one case, and the attorney in the other case. I know the one of them was very complicated, but in the past, the staff would explain to us what the A&R was all about, and it was like a 2-minute operation. So I don't know if we've changed the way we're going to handle A&Rs in the future because we're on Zoom meetings, or if you want to think about how we're going to do this.
John, my comment to you is, in general, I feel extremely handicapped as a planning board member because we cannot go up into the planning office and see these large size plans and discuss them with staff. So I feel extremely handicapped. Tom?
My phone is always on for you guys to give me a call and talk about them. We can talk about them on the phone. We can set up a Zoom with them. I can meet you on the curb if you'd like, but we're in the circumstance that we're in. I'm always encouraging the board to reach out to me, and not that I'm lonely, but I'd love to hear from you if you got something on your mind to ask me about. I like to think I'm pretty readily available, even though Paul Dreyer will tell you it takes me a while to get calling back sometimes.
Well, I just feel, I agree with what Pat's saying. We feel like we're handicapped, but I would rather see you make the presentation if it's complicated, and not get the representative of the applicant involved any more than is necessary. The first one seemed complicated. As an A&R plan, it is not complicated. It either is or it isn't, and you can certainly explain that to us. That's how I feel about it, but I'm just one member of the board.
I agree with John.
Yeah. Jim?
Yeah, I agree with John wholeheartedly. One of the things in my experience is if you let somebody talk about it at a meeting, then you got to let somebody go on the other side, and the whole agreement can go down the road and get really messed up. And that's why we have to be careful about when we bring in comments on that, because if there was any objection on the other side, they'll be slighted if they don't have it, and then a debate starts, and we're not supposed to be debating an A&R.
Okay, so henceforth, no representatives for A&R. They will have done their pitch to Tom initially, and he can do it to us. All agreed?
Yeah.
Yep.
Okay, Tom?
Oh, just one more thing, and I hate to be that guy, but if I have a plan that comes up and says the staff and I are looking at this and sorting out what the issues are, and the applicant says, okay, the staff has said you're looking at this thing and sorting out what the issues are, then maybe we'll let the staff look at things and sort out what the issues are versus, oh, well, that seems fine, and vote it. So, I'm always looking to spend my time as valuable as possible for the board's edification. So if I got something that I'm sorting out and I'm not, quite comfortable to give you the information that you might be looking for, and I say, well, we're figuring this out, we're having this conversation, we can bring it up in a couple weeks, then that's up to the board whether you want to say, well, let's go with what the planner said and bring it up in a couple weeks, or let's listen to what this guy said and vote it tonight. This was particularly complex. There's a lot of different moving parts on it. Chances are there would have been notations on the plan that talked about, zoning and, the siting of septic systems and things like that. But we'll see some of that in a couple of weeks when we've got the special permit in front of it.
Well, is it possible then, Tom, I'm addressing this to you, that if there are too many moving parts and you are not satisfied because there are still questions that you need to iron out with the applicant, you tell the applicant not ready for prime time yet until those are ironed out to your satisfaction.
Right.
Well, this is the thing that's different about an A&R plan as anything else, is that the board shall forthwith endorse the plan within 21 days if it has frontage. In the age of COVID, we don't have that 21-day clock running, but we do now. And in this case, as we said, we've got this application in. We had a meeting last week and trying to sort through all those things. That's why I had a conversation with Bob about it today to fully understand more what was going on with the application.
Hey, Pam, can you mute because I'm hearing you shuffling through things? Thank you.
So, we're doing our best to process information for you and get it out. And in some cases where we haven't been able to sort that out, we let you know. We haven't sorted it out, but the board seemed comfortable with it after the applicant's attorney pontificated for the time that he did. Most of the A&Rs, the simple ones are done. Most of the ones that we see these days aren't quite so simple. And in this case, it wasn't quite so simple. We had a number of conversations about it and still trying to sort it out for you.
Okay, so I guess the answer to that, John, is it depends.
Well, I don't think it should depend, but there's always town council if it's too complicated, but I think that the town planner should be able to answer our questions.
Yeah.
That's how I feel about it. So.
Okay. So to that end, Tom and Michaela should do their best, right? So that we don't have to have a representative.
Yes, thank you.
Okay. Okay, anything else? Because if not, this meeting is adjourned.
Bye.
Night.
Good
Good
night.
night.